A very good morning to all presiding officers holding courts under POCSO Act 2012. On behalf of Chandigarh Judicial Academy, I, Harshali Chaudhary, faculty member cum additional district and sessions judge, welcome you all in today's webinar. The topic for today's webinar is grant of compensation in the cases under POCSO Act 2012. Now, as we all are aware that under Section 33 of the Act, the special court is empowered to grant compensation to the child victims in appropriate cases as in addition to the adequate punishment. However, there are many ifs and buts, what and why, how and when, and from whom the compensation is to be granted. Now, in order to enlighten us on this aspect, I welcome Madam Sonia Kinra, faculty member cum additional district and sessions judge, to throw some light on the same. Now, briefly introducing ma'am. Ma'am joined Punjab Civil Services Judicial Branch in the year 2004, and after having held several assignments, she joined Superior Judicial Services in the year 2016. She also had the opportunity to hold the court under POCSO Act as one of her assignments. She joined Chandigarh Judicial Academy in the year 2021. A very good morning to you, ma'am, and I welcome you. Now, it would be worthwhile to mention here that unlike the previous webinars, this webinar would be an interactive one. As such, the participants can interact with the speaker. So now, without further ado, I request ma'am to take the session forward. Ma'am.
Thank you, Harshali ma'am, for introducing me. And good morning to my all worthy colleagues. Firstly, I am thankful for the enthusiastic, overwhelming response to the questionnaire circulated on today's topic from the Academy. In my view, the children not being the voters' bank for the democracy were kept in the back seat. This is reflected from the fact that the sexual offences against them were recognized in the year 2012, despite the fact that India acceded to the Convention on the Rights of the Child conducted on 11th of December 1992, adopted by General Assembly of the United Nations. Though the Act came into force on 14th of November 2012, but still it has not been implemented in its true spirit, letter and spirit. There are many nuances at every stage, from registration of the FIR till conclusion of the trial. However, today we are concentrating only on the aspect of compensation to the child victim under POCSO Act. And what is need to concentrate on this aspect? It is the data which has been mentioned in the recent case, which is still pending before the Honorable Supreme Court, that is alarming rise in the number of reported child rape incidents, bearing SMW criminal number 1/2019, wide order dated 13th of November 2019, where the data was supplied from all over India by all the high courts of the different states and even by the states. And in this data, it has come to the knowledge that the percentage of interim compensation which is not being provided is 99%. And thus, the percentage of interim compensation which is being provided is only 1% of the cases. Similarly, is the condition with the final compensation. In cases where it is not being provided, the number is 99%, and the number where it is being provided is only 1%. Long line of judicial pronouncements of various high courts and apex court reflects that there is a shift from retribution to restitution. Rehabilitating the victim is as important as punishing the accused. And the plight of the victim cannot be ignored even when a crime goes unpunished for want of adequate evidence or even for want of the accused who is not traced. So that's why there is a great need to concentrate on this topic we have chosen today. Now, firstly, I would like to brush up the provisions regarding the compensation under CRPC and then under POCSO Act 2012. Whether my PPT is being shared with all of you?
Yes, ma'am.
All right. Now, Section 357 CRPC is regarded as the step forward in legislation. It recognized the philosophy of compensation helpful for the victim even where no sentence or fine is imposed. As we all know under Section 357 Subsection 3. I have prepared this PPT and I am sharing with you with regard to the provisions of CRPC also so that it is ready reference for all of you. We all know that Section 357 is the only provision under the general law that governs the victim's compensatory rights. And as per subsection 1 of this section, when fine is imposed and it forms part of any sentence, including sentence of death, the court may at the time of passing judgment order the whole or 357 subsection 1. It is only applicable when we impose a fine. And fine is part of the sentence, which may be a sentence of death. So the entire fine, or please switch off your mics. You can switch on them when there will be interaction. And the sentence could be of death or otherwise. And the court may at the time of passing judgment can order whole or any amount of fine recovered. And there is another subsection of this section, that is subsection 3. This is applicable when fine does not form part of the sentence, meaning thereby that we don't impose fine when we pass this sentence. Now, there are two differences in subsection 1 and subsection 3. One, as I have already told you, that it comes into play when we impose a fine, and 3 comes into play when we don't impose a fine. And under subsection 1, there is a cap on grant of the compensation. That is, it could be either whole of the fine or part of the fine, and the fine part is prescribed under the IPC. But under subsection 3, there is no cap on the compensation to be given, as you are not granting it from the fine. So these are the two differences between both the subsections. Now comes into play section 357 capital A. It states that every state government in coordination with the central government shall prepare a scheme for providing funds. That is, for which purpose? It is for the purpose of compensation to the victim. And it's not only to the victim, but also the dependents who have suffered loss or injury as a result of crime. that loss or injury must be result of crime and they require rehabilitation after commission of that crime. So the recommendation is to be made to the DLSA by the court which has conducted trial, which has granted punishment, and it has come to the conclusion, satisfaction, that the compensation granted by that court may be under section 357 subsection 1 or 357 subsection 3 is not adequate for such rehabilitation. This is the first ground when you convict. And apart from it, the compensation under 357A can be recommended when the case ends in acquittal or discharge. And on the other hand, victim has to be rehabilitated. Then the recommendation for compensation can be there. I am reading this 357, which is a general law of CRPC, applicable to the IPC cases and other cases apart from POCSO. There is difference with regard to these provisions under the POCSO that I'll come to later on, just within few minutes. Now, what is the next provision under which the recommendation can be made is where the offender is not traced or identified, but the victim is identified and where no trial takes place. Here also again, the victim can be granted compensation. Then when you make the recommendations of the compensation, then DLSA shall conduct the inquiry and thereafter award adequate compensation by completing the inquiry within 2 months. Now, this is for subsection 4 where the trial has not been conducted. Next comes the state or the district legal service authority has to provide immediate first aid facility or medical benefits free of cost to the victim who is suffering. And it could be on the certificate of the police officer, not below the rank of the officer in charge of the police station or magistrate of the area concerned. And it even can grant any other interim relief as the appropriate authority deems fit. So this is all about section 357 capital A with regard to our today's topic. And pertaining to the POCSO cases where there is difference, I'll tell you that difference also. Now with regard to this general law, even the Honorable Supreme Court has held in the case of Hari Kishan versus Singh that compensation is not ancillary to other sentences, but it is in addition thereto. So the payment vary depending upon the act of each accused, and even reasonable period for payment of compensation can be granted. Even it can be facilitated to him to pay in installments. Next comes the case of Manohar Singh versus State of Rajasthan, 2015, Volume 3, SCC 449. Here also, again, it has been held that rehabilitating victim is as important as punishing the accused. And where the accused is not traced or he is not punished for want of adequate evidence, even then the plight of the victim cannot be ignored. Then comes the Suresh and another versus State of Haryana. This is of our own Honorable High Court. Criminal Appeal number 420 of 2012, decided on 28th November 2014. It again presses upon the grant of compensation where rehabilitation of the victim is required. And the award of such compensation can be interim even. Then comes the case of Kumar Rao versus State of Sikkim, 2017, SCC Online, Sikkim 152. In this, the Honorable High Court of Sikkim at Gangtok held that the trial judge may be faced with the situation that in addition to the punishment, compensation must be directed to be paid. And in such situations, the trial court is not helpless. It can direct the payment of compensation as per the compensation scheme. And even the special court is required to ask itself as to what is required to rehabilitate. So it is like that there are the authorities on the will that when you decide the question on will, you sit on the armchair of the person who got scribed the will. Similarly here, just the special court asks itself that what is required to rehabilitate the victim, looking into the factors which are granted under the rules. Kindly switch off your mics, please. I know that all of us are working from home today, but still we have to follow the protocol. Now coming to the POCSO Act. Subsection 8 of Section 33 of POCSO Act is the section dealing with the compensation. It states that in appropriate cases, the special court may, in addition to punishment, direct payment of such compensation as may be prescribed to the child. For what purpose? For any physical or mental trauma. So the trauma does not include only physical part, but also mental, which has been caused to the child by commission of such offense and is required for immediate rehabilitation of such child. These are the major factors when Section 33, subsection 8 comes into play. Earlier, there were rules of 2012 when the Act came into enforcement, but in the year 2020, from 9th of March 2020, the rules have been amended. Though with regard to compensation, earlier the rule was Rule 7, and now it is renumbered as Rule 9, but the provisions are same. However, I'll let you know about this. Rule 9, Clause 1, special court may in appropriate cases. I lay stress on the words on its own, that's suo motu, or on an application filed by or on behalf of the child, pass an order for interim compensation to meet the immediate needs of the child. For what purpose? For relief or rehabilitation, and at what stage? After registration of the FIR. Such interim compensation paid to the child shall be adjusted against the final compensation. I'll stick here to this rule. It is specifically mentioned that after registration of the FIR, the special court on its own can grant interim compensation. Now the question arises that when the FIR is lodged, how the special court will come to know that it has been lodged, because these special reports are not being sent to these special courts under the POCSO Act. They are till date being sent to the concerned magistrate, Ilaka magistrate of the area. So, firstly, we have to request our learned session judges that the special court under the POCSO Act must receive the copy of FIR. And that copy of FIR be also sent to the DLSA, because there are many obligations, many parts to be performed on part of the DLSA as well after registration of the FIR. Only after receiving such FIR, you can on your own pass an order for interim compensation if you feel it appropriate. And second thing, that whenever interim compensation is paid to the child at any stage, that interim compensation has to be adjusted against the final compensation, and a specific order has to be passed at the end if the final compensation is granted, that such and such amount was paid as interim, such and such amount is paid as compensation, and after subtracting the amount of, after adjusting the amount of interim compensation, such and such amount as final compensation be paid. Now, next comes Rule 9(2). The special court may, on its own again, or on an application filed by or on behalf of the victim, recommend the award of compensation where the accused is convicted. Now, again, this is the wording picked from Section 357, capital A, that the recommendation of the award of compensation in case of the conviction, or where the case ends in acquittal or discharge, or the accused is not traced or identified, and in the opinion of the special court, the child has suffered loss or injury as a result of that offense. Now, the question again crops up that when the wording is with regard to recommendation of the award of compensation, then how and why the special court can quantify the amount? The answer to this question is in Rule 9(3). It has been mentioned. I read with subsections 2 and 3 of Section 357, capital A of CRPC makes a direction for the award of compensation to the victim. It shall, the word is shall, take into account all relevant factors relating to the loss or injury caused to the victim. If the intent, purpose of the legislation was that the special court has not to quantify the amount, these relevant factors should not have been mentioned to be considered by the special court. But here the special court is obliged to take into account all relevant factors while awarding the compensation, deciding the quantum of compensation. And what are these factors? These are the type of abuse, gravity of the offense, severity of the mental or physical harm, the expenditure which has been incurred on such medical treatment, loss of educational opportunity, employment, which is the consequence of the offense, which could be due to absence from the school or the place of employment, that could again be due to mental trauma, bodily injury, medical treatment, investigation, trial, or any other reason which is connected to the commission of the offense. Then even we have to consider the relationship of the child to the offender, whether this is incest or the offender was from outside, whether the abuse was single incidents or it has been committed over a period of time, whether the child as a result of the commission of offense became pregnant, whether the child contracted the sexual transmitted disease or human immunodeficiency virus, which we call as HIV, or any other disability has been suffered by the child as a result of the offense, which could be physical or mental. And even the financial condition of the child against whom the offense has been committed is to be taken care while determining the quantum of compensation to be awarded and then to be recommended to the DLSA. Apart from these 11 factors, the special judge has been given vast power to consider any other relevant factor which could be there for deciding the quantum of compensation. Now the compensation which has been awarded by you as special court is to be paid by the state government from the victim compensation fund or other scheme or fund which is established under section 357 capital A of CRPC or any other law which is in force. That is the duty of the DLSA when we pass the order on the quantum of compensation and then recommend the same. The state government shall pay the compensation ordered by the special court within 30 days of receipt of such order. This is there under Rule 9(5). Then comes that this is again very important clause 9(6), which states that nothing in these rules shall prevent a child or his parent or guardian or any other person in whom the child has trust. So anybody can move the application on behalf of the child, who includes the child himself, his parent, guardian, or any other person in whom the child has trust and confidence, from submitting an application for seeking relief under any other rules or scheme of the central government or state government. So the grant of the compensation under these rules by the special court is not a bar to the child or on behalf of the child for moving an application for seeking compensation or any other relief which he could or she could under any of these schemes may be floated by the central government or the state government is entitled. Now, there are very important judgments on the compensation under the POCSO Act, which reply to the questions with regard to which the questionnaire was circulated. First is the state of Chhattisgarh versus Dilip Verma and others. Manu CG 0206-2017. Though the provision of Section 33, Subsection 8 and the rules earlier, which was Rule 7 of 2012, and now it is Rule 9 of 2020. The same thing which we have studied has been held by the High Court of Chhattisgarh. But it has been held here also, as in this case, the additional session judge quantified the amount, and the recommendation was made to the DLSA to pay the specific amount against which the state filed the appeal, and it was held that the additional session judge trying offences in the POCSO Act is fully empowered to award compensation to the victim, and this power is an additional jurisdiction conferred to the special judge. It was held that the special judge is empowered to quantify the amount. Thereafter came the case of Bijoy. It is Bijoy versus the state of West Bengal, 2017, Criminal Law Journal 3893. In this case, Honorable High Court of Calcutta laid down many guidelines with regard to the investigation, trial, but I have curled out the guidelines which are only for compensation. These guidelines have been reiterated in the very well known case of Nipun Saxena by Honorable Supreme Court. These guidelines have been reiterated in that judgment. It states that the special court, while dealing with such offences, may make orders of interim or final compensation to victim from the fund made available by the state. Further, clarified that the Section 33(8) POCSO, along with earlier Rule 7 of POCSO rules, make amply clear that power of the special court to award interim or final compensation is not restricted to the terms of victim compensation fund, meaning thereby you can enhance the amount. It is not that which is mentioned in the NALSA or the Haryana scheme or the Punjab scheme, but in the circumstances given, when the special court finds it appropriate, then by assigning the reasons, the amount can be, any amount can be awarded. The amount should be reasonable and just as may be determined by it in the facts of the case, and within parameters that are laid down now in Rule 9(3) of the rules we have gone through. Next guideline is that upon orders being passed by the special court relating to such compensation, the state government shall pay the compensation so ordered by the special court within 30 days of the receipt of the order. It could be by itself or through the SLSA or DLSA, where the victim compensation fund is entrusted. Then next is that it shall be open to the special court in appropriate cases to grant compensation over and above the limit proposed under the scheme, in as much as the scheme merely lays down the minimum limits and does not provide for an upper limit which is left open to judicial discretion of the court, but again within the parameters of Rule 9(3), not 7(3) now. Then the special court, upon receipt of information as to commission of any offence under the Act by registration of FIR, shall on its own or on the application make inquiry as to the immediate needs of the child. Now, the question also arises here that how the inquiry can be conducted of the immediate needs of the child. That what is required for relief of rehabilitation. Firstly, I have told you that the FIR just asks that the copies of the FIR should be sent to the special court. Next, there is the Form B. Form B, it is with the rules of 2020. This is the preliminary assessment report. And this preliminary assessment report has to be conducted of the concerned SHO and has to be submitted to CWC. You can ask the investigating officers that this report should also be submitted in the special court. Copy of this report be sent so that the court can come to the conclusion that what is the immediate need of the child and what quantum of amount can be released for as interim compensation. Next comes whether the accused is convicted or not, or in cases where the accused has not been traced or had absconded. Now, where the trial is pending before you, challan is pending before you, you can grant the compensation. But the cases where case is not pending before the special court, the accused has not been traced or had absconded, again, the special court has the power to grant compensation, that is after inquiry. So again, the DLSA will not consider the applications in these cases, but you have to conduct inquiry and determine, quantify the amount of compensation and recommend that amount to the DLSA, which has to be paid by the DLSA. Now, again, the determination is on the basis of the factors, 12 factors, which are under Rule 9(3). Now comes the case of Nipun Saxena. Nipun Saxena and another versus Union of India and others. 2019, Volume 13, SCC 715. Here, as I have told you, the guidelines given in the Bijoy case have been reiterated. Further, it has been held that the special judge will pass appropriate order regarding actual physical payment of the compensation. It is again making it clear loudly that the actual physical payment, which has to be granted as compensation or interim compensation, the order regarding it has to be passed by the special judge. The purpose is that it may not be misused or misutilized and is actually available for the benefit of the child victim. Even if the special court deems it appropriate, an order of depositing the amount could be in an interest-bearing account. Even there are judgments of the Honorable Delhi High Court that if amount is quite big, the amount has been paid in phased manner. In one of the cases, it was like 3 lakhs was to be paid. So the FDRs which were got prepared, they were at the intervals of little amounts, maybe of 10,000 in the month of June, 10,000 in the month of July, like this, so that accordingly the interest could be there, and that interest could also be deposited in the saving account of the child, so that if the child requires for the education, for medical purposes, or any other rehabilitation, that amount could be used immediately there. Now, the next question which comes to the mind, that whether multiple applications for interim compensation can be made. Though there is no provision under the rules, but on the other hand, there is no bar even of moving the second or subsequent applications for interim. In the case of mother minor victim number 1 and 2 versus state and another, bearing writ petition criminal 3244 of 2019, decided on 15th of June 2020. Apart from holding that it is incumbent on the special court to pass necessary orders for compensation or interim compensation in appropriate cases, and that it is not open for the special court to delegate the said power to the concerned SLSA or DLSA to pay the amount. It has been held that though there is no provision under the POCSO rules with regard to multiple applications for interim compensation, but as the provision is a beneficial one, the subsequent applications must be considered liberally. And such subsequent applications would be maintainable only if circumstances have subsequently arisen that were not in contemplation at the time when the special court had evaluated the requirement of interim compensation, meaning thereby that some other need has arisen after decision of the first or the second application for interim compensation. In this case, what happened? The mother of the minors, there were two victims, both daughters of the same mother, that were sisters. The mother of the minor moved the application for interim compensation. The special court quantified the amount to rupees 50,000 and recommended to DLSA. That amount was paid to the victims. Thereafter, sometime, another application, second application, was moved for more interim compensation. On the argument of the state, the special court, it sent the application to the DLSA to consider, as it has already passed the order, and it recommended to the DLSA. The DLSA, again dismissing the application, stated that it has no power to review the order of the special court, and the special court has to pass the order on compensation and the payment can be made by DLSA. Both these orders were assailed before the Honorable High Court, and thereafter it was these observations which we have discussed, that the second application for interim compensation is maintainable, but there should be circumstances subsequently arisen, and that application has to be decided by the special court. You may or may not grant compensation, interim compensation, but the application has to be disposed by the special court. Now, there is the case of Rajkumar versus State, 2020, volume 266, DLT 179. As I was referring, that in phased manner, the compensation was granted. It was same in this case, but the Delhi High Court took note that in many of the cases in which the acquittal was there, in which the accused, the victim did not stand. She turned hostile. The special court granted the compensation. These were the examples quoted therein, that the prosecutrix was disbelieved, but the compensation was only granted because the child was begotten, and it was reasoned that without a lawful marriage the child was begotten and might suffer the stigma of illegitimacy. And there was another case that again the prosecutrix, she admitted that the case was falsely engineered with ulterior motive, but she was granted the compensation on the ground that she is from a poor family and in need of financial help. Thus, it was held that these cases have been held to be illustrations of grossly irresponsible use of public funds governed by victim compensation scheme. The compensation is to be provided from scheme held in trust. Public money placed at disposal of judicial organ cannot be allowed to be abused, misused, or pilfered. So this was held in this case law, though again I stress upon that it does not bar the special court to grant compensation even in the cases where there is acquittal. But we have to be careful that on what basis the acquittal is there. For short reference, I have just prepared a chart that if there is conviction, then compensation has to be quantified by the court and recommendation to DLSA to pay the same, who will get it deposited in the bank account of the victim or joint account of victim and guardian within a period of 30 days. But if the compensation in the cases of conviction is not being granted, the reasons have to be assigned. The latest law now shows that the reasons have to be assigned even to reach at the quantum of the amount of compensation to be awarded. And if you are dismissing the interim compensation, application for interim compensation, or you are not granting compensation when convicting the accused. Now, in case of acquittal, two eventualities occur. First is the acquittal is due to non-believing the version of the prosecutrix or victim. And second is due to insufficient evidence. In the first eventuality, no compensation can be granted as the prosecutrix does not fall under the term victim. What is victim? It is defined under Section 2WA of the CRPC, and it has to be established that there has been an act of commission or omission which has resulted in loss or injury being caused to the person. He is the victim. But if you are not believing the version of the prosecutrix, you are not considering him as the victim, then she is not entitled to the compensation. So compensation of an offense is prerequisite to the rights of the person who has consequently suffered loss or injury. If no offense has been committed, the purpose of criminal law, there cannot be a victim. But on the other hand, if acquittal is due to insufficient evidence, if it is found that this is not the accused who has committed the offense, but there is some other accused who is not raised or whatever, the evidence is insufficient against the accused, and again you are finding it appropriate and satisfied that for relief or rehabilitation, something should be granted to the victim, then after quantifying, the recommendation be made to DLSA, and again the amount will be deposited by them within a period of 30 days. Now coming to the third eventuality, that is where the accused is untraced. As we have already undergone Rule 9, it mentions that special court may, in appropriate cases, at its own or on an application on behalf of the child, pass an order for interim compensation to meet immediate needs of the child or relief or rehabilitation at any stage after registration of FIR. So with regard to the interim compensation, when there is conviction and the interim compensation has been granted at any stage after registration of the FIR, it is the duty of the special court to mention that such and such interim compensation has been granted, and that interim compensation has to be adjusted in the final compensation. Now, if interim compensation has been granted, but there is acquittal, then again, if it is due to insufficient evidence, then the prosecutrix who could be granted final compensation, the interim has to be adjusted in the same. But if again it has been found that no offense has been committed, you disbelieve the version of the prosecutrix, then the interim can be recovered by DLSA, which is under the NALSA compensation scheme for women victim 2018, which is followed in the Punjab, and under Rule 13 of the Haryana compensation scheme for women victim 2020. Now, in the state of Punjab, though there is the Punjab victim compensation scheme, but this scheme is prior to Nipun Saxena case. That is, this is of 2017, whereas Nipun Saxena case is of year 2018. Therefore, the NALSA compensation scheme is being followed. And in Haryana, though this scheme has been floated, but this is paramateria to NALSA scheme. These are the schemes, and this is all about the compensation on this. What I have prepared is a PPT, and even in the questionnaire which was circulated, I think the answers to all the questions have been replied by me in the entire session. But if any query is there, any point is left to discuss, we can discuss it now. Before starting, whoever wants to interact, kindly let us know the name. Yes, officers.
Nothing is left, ma'am.
Yes, Bhavna ma'am, nothing is left.
Out of the questionnaire. But I have a query.
Otherwise also, yeah, yes, otherwise also, we are here to clear the points on this compensation. Any nuances you have, any doubts, we are all here to clear that. Yes.
I have a query. May I put?
Yes, yes, yes.
When the compensation is recommended, quantified and recommended to be paid by the DLSA, and it is not
Yes.
paid, then whether the victim can approach the special court or the DLSA alone for the recovery thereof.
Then he can approach, I think, to the DLSA that such and such amount has been quantified and recommended. The chairman of the
But
DLSA is
sometimes
there. Yes.
DLSA chairman or secretary. Firstly secretary, and if any grudge, then
Yes.
DLSA chairman.
Chairman also.
Right.
Yes.
But sometimes, ma'am, it so happens that from the Honorable High Court, we receive an order that compensation of such and such amount be disbursed. In
Right.
that eventuality, DLSA does not initiate any proceedings, and we initiate the proceedings to issue notice to the victim. Victim appears, but she is not having the proper documents, such as like her identity card, saving bank, Aadhaar card, जो भी documents होते हैं, we are not much aware of those documents. In that eventuality, can we refer the victim to the DLSA for compliance?
Now in this situation, when you are not having any document that whether this is the real victim, either you will direct the investigating officer to bring the victim if you want to initiate the proceedings. Otherwise, it is the duty of the DLSA.
I'm not asking about where the victim's identity is not there. I am asking if the case has been disposed of, say, around 7-8 years earlier. And now we get the order from Honorable High Court. कि जिसमें उन्होंने या तो कंफर्म कर दिया ऑर्डर या फिर उन्होंने मॉडिफाई कर दिया. उसमें हमने फाइल मंगाई, डीएलएसए ने क्योंकि जो ऑर्डर की कॉपी है वो डीएलएसए को भी गई है, लेकिन दे डिडंट इनिशिएट एनी एक्शन. बीइंग स्पेशल कोर्ट, हमने उसमें नोटिस किया विक्टिम को, विक्टिम आ गई. एम आई ऑडिबल?
यस यस यस.
विक्टिम आ गई और वो लेकिन अब उसके पास कुछ भी नहीं है. In that eventuality, at that stage, should we refer the victim along with the papers to the DLSA? क्योंकि हमारे पास ये सारा काम करने के लिए टाइम भी बहुत कम होता है. देखिए, to be very honest.
भावना मैम, here is the question. आप ये भी बोल रहे हैं कि विक्टिम आ गई, विक्टिम के पास कुछ नहीं है,
डॉक्यूमेंट नहीं है, हम उसको
कुछ नहीं है, that her identity is disputed.
Identity नहीं, means she is not having her ID card, saving bank, PAN card, Aadhaar card, whatever is needed.
That's what I am stating, that you can call the investigating officer, that who can identify that this is the same victim.
Okay, we will call
initiated the proceedings on the order of the Honorable High Court. Otherwise, you could have write a request letter to the chairman of the DLSA that this is the situation and kindly look into it. But if you have started with and her identity is disputed, first inquiry has to be conducted that she is the same victim in that case. And that inquiry can be conducted by DLSA. You can write in detail about the things that this is the situation and the victim is in the court and we are referring the victim to the DLSA. So after due procedure, you can award her the amount whichever has been upheld by the Honorable High Court.
हाँ, मतलब वही है कि हम विक्टिम की प्रेजेंस इंश्योर करने के बाद, आइडेंटिटी इंश्योर करने के बाद, we should refer her or him to the DLSA. क्योंकि अमाउंट भी जो रिलीज करवानी है.
जी.
हाँ जी.
यस यस. यस यस बोलिए.
मैं ये कह रही थी कि जो अमाउंट भी रिलीज करनी है वो DLSA में ही करवानी है.
Yes, yes. That's why even it is the duty of the DLSA to conduct inquiry also, that she is the same victim or even to summon the victim.
ठीक है.
So that the amount can be dispersed as per the orders of the Honorable High Court.
12:35 होगी. कितने बजे अभी क्लास है?
तो मैं बोलूँ?
Yes, 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 मैम.
तो ऐसे में मैम जब हमारे पास कोई ऑर्डर आता है तो हम उसमें फिर DLSA को भी उसमें ऑर्डर कर सकते हैं.
Yes, you can request the chairman of the DLSA.
अरे करो.
Chairman.
942 बाद में कंप्लीट करते रहना. 3692.
Please switch off the mic, remaining officers. Please switch off the mic. Yes. Yes,
तो
Bhavna
मतलब
ma'am.
मैं ऐसे सेक्रेटरी को हम डायरेक्ट कर सकते हैं, और चेयरमैन को अगर हमें लगे कि
Yes.
सेक्रेटरी ने कोई इनिशिएट नहीं की, देन वी कैन रिक्वेस्ट
We
the chairman.
can request the chairman.
So we will keep a track on the proceedings initiated by
Otherwise,
DLSA.
DLSA has to send a letter and the record that such and such amount has been dispersed to the victim in such and such case.
ठीक
And
है.
if it has not been, so you can ask them that whenever it is dispersed, let the special court be make aware of this so that it can be made part of the file.
ठीक है मैम. अब मेरी एक और क्वेरी थी मैम, पूछूं?
जी मैम.
हम जब फाइन अमाउंट में से कंपनसेशन देते हैं, तो अब एज पर द रूल्स ऑफ 2020, it is a
Yes.
duty of CWC to ensure that payment has been made to the victim.
Right.
ठीक है. In such an eventuality, we forward the copy of order and judgment to the CWC chairman as well for necessary compliance.
Yes.
क्योंकि अमूमन मेरे ख्याल से ऑलमोस्ट 100% केसेस में फाइन हमारे पास अनपेड रहता है.
जी.
बहुत कम, रेयर ही होता है कि फाइन हमारे पास पे हो जाता है. तो हम उनको भेज देते हैं कि जब भी फाइन रिकवर होएगा, इट इज योर ड्यूटी ऑल्सो. ठीक है. तो ऐसे में अगर CWC चेयरमैन या मेंबर हमारे पास कोई प्रॉपर्टी की डिटेल लाते हैं कि उसकी कि जी ये इसकी प्रॉपर्टी है, तो अब उसमें हम इनिशिएट करें रिकवरी के लिए कलेक्टर को भेज के, या फिर हम वेट करें टिल द फाइनलाइजेशन ऑफ ऑर्डर जजमेंट? क्या करना चाहिए?
Otherwise, compensation as per section 357 cannot be recovered till the decision in the appeal is given or appeal is filed. So I think that till that we cannot get it executed, in my view.
ठीक है, लेकिन एक और बात है ना मैम, वी आर इम्पोजिंग द फाइन.
Yes.
And as per some
And if
provisions, some
appeal has
punishments.
been filed against that order, within 30
appeal
days,
appeal
appeal is pending there.
Appeal is filed or would be filed,
Before
whatever
the
may be.
Honorable High Court.
लेकिन
So-
एक और बात है ना मैम, हमने
जी।
सिर्फ कंपनसेशन नहीं दिया, हमने फाइन किया, और एज पर प्रोविजंस ऑफ पॉक्सो कुछ एक ऑफेंसेस में है कि जितना भी फाइन होगा वो कंपनसेशन एज कंपनसेशन रिलीज करेंगे हम विक्टिम को.
Yes.
So that is the fine amount, not compensation only.
So we are talking only of the compensation amount, no?
नहीं मैम, जैसे अब मान लीजिए
You want to say that the fine amount, total fine be recovered and thereafter the compensation be paid from that fine amount to the victim.
जैसे हमारे पास सेक्शन 6 सेक्शन 376 डी है IPC. So in that eventuality the entire fine amount shall be released as compensation to the victim. तो फाइन हमने उसके ऊपर मान लीजिए कर दिया 1 लाख या 50,000 whatever may be, वो फाइन अनपेड है, और हमने ऑर्डर कर दिया फाइन इफ रियलाइज्ड be released in entirety as compensation to the victim. Then in fact it is a fine. So in that eventuality, what should be the course?
Ma'am, I think I should thrash this point and then revert to you before answering it the other way, or right? This is and anybody else who can enlighten on this point or who has passed any order on this, please, they can enlighten us rather.
Sure. जी मैम.
Anybody from the audience? I think nobody is turning up.
इसको क्रैश आउट कर लेंगे मैम, क्योंकि मैं काफी कोशिश कर रही हूँ, मुझे मिल नहीं पा रहा.
No problem, ma'am. We'll thrash out this. Any
मैं
other
आपसे टच में रहूंगी.
Excuse me, ma'am.
Yes.
If a victim is stand hostile and the application for interim compensation is already pending, generally what should the order we should pass?
It is not the generally, yes. It is not the generally, but we have to look into case to case. And even in the Punjab scheme, though it is only the guiding factor, but when the prosecutrix or the victim turns hostile, it is a disqualification for grant of either interim or final compensation. So you can take note of that. When the victim does not support the case, then generally, in my view, when she is not supporting the case and you are prima facie, it is looking that she is turning hostile, maybe on the basis of compromise or pressure or any other reason. Whereas she has stated so in FIR, she has stated so in 164 statement, then she is not entitled to the compensation, interim compensation.
Suppose, ma'am, we are noticing that she has been turning hostile on the pressure of their parents, and this factor come. Hello.
Yes, yes.
If you are getting that she has been turning hostile on the pressure of their parents,
right,
and it is coming in our notice that she is poor enough, and maybe this kind of factors are always there in the society, that they are pressurized by their parents. And even then, is there any chance that we can grant the compensation?
So, sir, again, we have to apply our judicious mind that whether we can note down these points on the while disposing of the application.
Ji.
If the medical evidence is there and she is turning hostile, medical evidence is there that you can convict in future on the basis of the medical evidence also, even if she has turned hostile.
Ji.
And you can reason your order, then I think you can grant it.
Yes, I can grant. What has happened?
Reason must be there, which
Yes.
is on the file and not on the assumptions.
What has happened before my court itself, ma'am? Father
sir.
was committing penetrative sexual assault upon his own daughter.
Right, sir. Right.
And
sir.
we know that the father is only earning hand in the family, and she was pressurized by the parents to turn hostile in the court. So I granted the bail also. But I thought that the compensation is required to be paid to the victim, because she has been regularly harassed, and randomly she was penetrated with sexual assault by the father itself.
Sir,
so in such a situation,
in order to rather avoid such situation, or you can say that to answer such situations, I was discussing with some officers, and I have also reached to the one of the conclusion. You may or may not apply this, but this is when the challan is presented.
Yes.
The DNA report is not there with the challan.
Ji.
You can press upon that DNA report should be there, or you can request the FSL, you can send a letter that DNA report should be there, and after passing the order, you can direct the IO to get the report by hand.
Ji.
In these situations, when DNA report is with you, is matching, you have the enough evidence, then it will help you in the conclusion of the trial as well, the deciding of such like applications.
Ji, ma'am, in this case, the DNA report is very much matching.
Oh.
Sir, excuse me, ma'am.
Yes.
Hello. अगर सर आपको ये लगता है कि फादर इज कमिटिंग पेनिट्रेटिव सेक्सुअल असॉल्ट अपॉन हिज ओन डॉटर सिंस बिगिनिंग, और आपको ये भी लग रहा है कि भी ये प्रेशर में दे रही है, और आपको फिर आपका डिसीजन क्या रहेगा? पहले तो आप ये देखो कि हमने जजमेंट में क्या लेना है, कि आप इसको कन्विक्ट करोगे या एक्विटल करोगे?
I'm not talking about the decision. I'm just talking about the
सर, तो ये तो
compensation.
माइंड तो आपको आगे उसको इंटरिम किसी चीज को हम देंगे तो हम ये लेके चलेंगे।
Definitely it is a case of conviction.
अगर इट इज गोइंग टू बी केस ऑफ कन्विक्ट, या आपको लगता है कि हम ये सारी चीजें देखते हुए भी इसको कन्विक्ट कर सकते हैं, तो फिर उसको हमें कंपनसेशन देने में क्या प्रॉब्लम है? अगर डीएनए मैच कर रहा है पेनिट्रेटिव सेक्सुअल असॉल्ट का केस है, फिर तो कोई दिक्कत नहीं है। मगर अगर हम सोचे कि उसको अगर हम छोड़ देंगे आगे, और अगर फॉर द टाइमिंग हम इमोशंस में आगे कुछ देते हैं, तो वो मजेदार बात नहीं है ना। हमारे को बिल्कुल क्लियर होना चाहिए इंटरिम देते टाइम भी कि एक बच्ची जो हॉस्टाइल हो रही है और फादर उसको पेनिट्रेट कर रहा है और डीएनए मैच कर रहा है।
I'm also in favor of granting the compensation, but this
Yes.
was only the question to clear my mind
हाँ नहीं, you
regarding.
can grant अगर अपने को लगता है ये कि भी
आपको रिप्लाई कंप्लीटली मिल गया होगा कि भी क्या होना चाहिए, क्या देखना चाहिए.
हाँ जी मैम, क्योंकि अगर हमें दिख रहा है कि बच्ची फादर में प्रेशराइज्ड है, ही इज द ओनली
Very
अर्निंग
right, very right,
मैच
very
मेडिकल
right.
सपोर्ट्स तो यू कैन गिव,
Yes,
मगर
yes.
सब्जेक्ट टू ये कि फिर फादर उस पैसे को ना खा जाए, इतना हमें ध्यान रखना चाहिए कि उस पैसे को उसको डिस्बर्समेंट कैसे करते हैं.
उसी के लिए ये जो प्रोविजंस हैं विद रिगार्ड टू द ओपनिंग ऑफ द अकाउंट एंड देयर आफ्टर गेटिंग इट
जी
डिपॉजिटेड इन
जी
द अकाउंट्स, ये प्रोविजंस
that is
इसलिए हैं,
clear.
और वो भी एफडीआर की फॉर्म में, सो दैट ऑन मैच्योरिटी द चाइल्ड कैन गेट द दैट मनी.
परमिशन भी तब दें कि जब बड़ा पता चले कि बच्ची के लिए ही यूज होगा पैसा, बस.
बिल्कुल बिल्कुल जी.
हाँ ठीक
जी. Any other query?
Ma'am, what should be the limitation of earning, like yearly earning of the family for granting the compensation? It may be approximately 250 lakhs, 2,50,000. What is the limitation, ma'am?
Limitation of what, sir?
That he has been having this much earning in per annum earning of the family for
इसमें
granting.
लिमिट नहीं है, इनकम की लिमिट नहीं है.
कोई इनकम पे रूल्स में या एक्ट में कोई प्रोविजन नहीं है. दिस यू हैव टू सी कि भी उस बच्चे के एजुकेशन के लिए, उसकी रिहैबिलिटेशन के लिए, उसकी मेडिकल के लिए कितना खर्चा हो रहा है और फैमिली की इनकम कितनी है, क्या वो बियर कर पा रहे हैं अपार्ट फ्रॉम देयर डेली रिवाइवल. उसके साथ जो है आपको कंपेयर करना है. इट इज नॉट द इनकम कि भी फैमिली की इनकम इतनी है तो आपने इतना करना है.
जी
जी.
थैंक यू मैम.
Thank you, sir. Any other query?
Ma'am, I am Saurabh Gusai. Can you, am I audible?
Yes, yes.
What if there are 5 or 6 accused persons and the victim turns hostile on only 3 of them, but supports the case against the remaining accused persons?
Yes.
And you have an inkling that there is the presiding officer has an inkling the reason why she turned hostile toward the remaining 3. Should the compensation be granted to her considering her act and conduct?
No, again, there is that Qua 3, she has turned hostile. And the presiding officer knows that why she has turned hostile. You mean to say this thing?
There is an inkling, like before lunch hours, she is identifying and she is supporting the case of prosecution. But after lunch hours, she says that no, these were she changes the statement immediately after lunch hour, saying that no, these 3 persons were not involved, but the remaining 3 persons were involved. So you know, there is an inkling. We come to know, yes, compromise has been reached between 3 of them. But she is supporting the case remaining 3. Should compensation be granted to her?
So compensation, if granted to her, with the interim compensation, she is supporting for the remaining 3 accused.
Yes, she is.
She is deposing against the 3 accused. She is not turning totally hostile. But again, you have to see the factors, remaining factors, that why the compensation is required at that stage. What are the purpose for that? Whether the factors which are there, they are included. So keeping in facts.
No, the law says that if she turns hostile, no compensation should be granted to her. So is it that it will have an effect on the quantum of compensation? Bas itna so ho sakta hai kya? Or should the compensation be completely denied to her?
If it is under section 357(1), then only from those accused who are going to be convicted there. Or if
what about the entire compensation? What should be? She is not completely supporting the case of prosecution. 164 mein she levels allegations against the remaining accused persons.
Yes.
यहाँ पर आके court
but
में
again, she is not completely hostile, no?
Yeah, she is not completely hostile.
She is not completely hostile.
मैं अपना व्यू शेयर करूं?
जी बिल्कुल.
ऐसे में सौरभ, अगर तुम उसकी कन्विक्शन कर रही हो, इंटरिम कैन बी डिक्लाइंड.
जी
लेकिन
मैम,
अगर तुम लास्ट में उन दो की कन्विक्शन करते हो जिनको वो सपोर्ट कर रही है, देन नेचुरली यू विल पे द कंपनसेशन. और अगर तुम उसको एक्विट करती हो, तो देन यू विल गिव द रीजनिंग दैट द प्रोसिक्यूट्रिक्स इज नॉट बिलीवेबल विटनेस.
And if she
तो
is
तब तुम
not
डिक्लाइन कर
believable,
सकती हो.
then no compensation can be granted.
हाँ,
नहीं
उसमें ये
मैम,
तो कहना ही
जैसे
पड़ेगा ना मैम हमें
अगर
एक्विटल में.
Yes, yes.
उसने 6 अक्यूज्ड के अगेंस्ट अलग अलग उसने एलिगेशंस लगाए हुए हैं. 2 के अगेंस्ट तो शी इज अलेजिंग सेक्सुअल असॉल्ट, और 2 के अगेंस्ट शी इज सेइंग कि मेरे को उठा के ले गए थे, एंड मतलब स्मॉलर डिग्री ऑफ असॉल्ट जो होता है 8 एंड ऑल सेक्शन 8.
Right.
मैडम भावना बिल्कुल ठीक कह रही है कि भाई जब
हाँ
तक
जी.
आप इस बात का कंक्लूजन ड्रॉ नहीं करते कि भाई कौन कितना कल्प्रिट है, कितनी इन्वॉल्वमेंट है, ये टोटल केस झूठ है कि वेदर सिंस बिगिनिंग शी इज अपना की हाफ अटेडली सपोर्ट कर रही है, कितना करेक्ट है, कितना वर्जन ठीक है, जब तक कंपोजिशन इंटरिम देना ही क्यों है हमने.
नहीं, बट जब इंटरिम की रिक्वायरमेंट हो तो फिर हम इंटरिम रोक भी नहीं सकते. या आप उसको डिक्लाइन करोगे या उसको ग्रांट करोगे.
हाँ,
आप इंटरिम
अगर
की
कोई
एप्लीकेशन
एप्लीकेशन
को
ऐसी
पेंडिंग नहीं
लगती
रख
है तो
सकते.
सपोज मैम ठीक है, हमने उसको इंटरिम कंपनसेशन दे दिया, जैसे ही वो आते हैं हम उनको इंटरिम कंपनसेशन दे देते हैं. उसके
Right.
बाद फिर एविडेंस होता है, और एविडेंस में उसका एक्ट और कंडक्ट ऐसा है कि हाफ ऑफ द केस शी इज सपोर्टिंग और हाफ शी इज नॉट सपोर्टिंग. फाइनल
Right.
में हमें ये होता है कि फाइनल में हाफ ऑफ द अक्यूज्ड पर्संस आर कन्विक्टेड बिकॉज ऑफ हर टेस्टिमनी, एंड हाफ ऑफ देम आर बीइंग एक्विटेड बिकॉज ऑफ हर एक्ट एंड कंडक्ट. So what should be
So
the status with respect to compensation?
if half of the are being convicted, then your quantum can be according to the according to that. And if you don't want to grant the quantum, you can mention the reasons for this.
मैम अगर हम कंपनसेशन देंगे,
just here, it
हाँ
is
जी.
not necessary here that you have to grant the quantum in every conviction case. But if you are not granting, you have to assign the reason. This is all.
Ma'am, on one hand, we are believing her to the extent of 2 or 3 accused.
3 accused.
And then why should we disbelieve her on the point of quantum of compensation? What those 3? अगर हम उसको विश्वास कर रहे हैं कि हाँ इन 3 के लिए सच बोल रही है,
yes, then
तो फिर हम उसका कंपनसेशन कैसे कहेंगे? नहीं, कंपनसेशन के लिए एंटाइटल्ड नहीं है, ये तो नहीं कह सकते ना.
तो that's why you have to, अब उसमें और क्या रीजंस आ गए हैं, कोई और इंटरवेनिंग फैक्टर है तो आप उसको जो है डिक्लाइन कर सकते हो. बट अगर ये कि वो 3 के एक्यूज के अगेंस्ट खड़ी है, 2 के अगेंस्ट वो स्टाइल हो गई है, तो इट डज नॉट मीन दैट द टोटल केस इज डैमेज्ड and you can refuse the compensation to her. It could be interim or it could be final.
Hello. जब हमें within 30 days
compensation would be granted considering the case qua the remaining 3 accused persons for which she has supported the case of prosecution.
Yes.
और जो पूरा उसका एक्ट एंड कंडक्ट है, that would not be considered कि भाई 3 के अगेंस्ट तो she turned hostile. एक बार क्रॉस एग्जामिनेशन में she is saying कि these 3 persons also assaulted me, and immediately after lunchtime she is saying that no, they did not assault me.
Now
she sticks to her point to the last.
Just here now, whether this factor came in the cross examination only or in the examination in chief.
In cross examination.
So she even identified all the accused in examination in chief.
Yes, first she identifies and then she says no,
So
I was mistaken, it was a case of mistaken identity, they did not do anything.
That was in cross examination thereafter.
Yes. So okay, it can be believed also. हाँ ठीक है, it can be seen कि सारा का सारा जो
you can take note of this.
यही लगता है कि भाई केस तो उसने प्रूव हुआ ही है, और हाँ ठीक है, fine. So compensation has to be granted to her because the assault did in fact take place.
Yes.
और जो बाकी
and the remaining accused are also being identified. Rather, all the accused have been identified, but in cross examination she has stated so. So this fact can be taken note of.
Fine, ma'am. Thank you so much.
Yes. Any other query?
No, ma'am.
Thank you everybody for such a cooperation and for such a long period. And Bhavna ma'am, I'll revert to you with regard to your query also. Thank you everybody.